Ladies and gentlemen, the European Court for Human Rights, its task is to enforce the requirements of the European Convention on Human Rights in the member states of the European Council. The most important provision for today's conference is Article 6, Paragraph 1 of the European Convention on Human Rights. According to this article, every person is entitled to a hearing by an independent tribunal. Let me say that independence is only one of the provisions requirements. Apart from that, the court must be impartial, established by a law. It must provide a fair trial, and it must make its ruling within a reasonable time. So you see, we don't have this guarantee because of the judges. They exist because of the people who want to file a suit. The ECTHR has no mandate to harmonize or unify the law of the 47 member states of the European Council. It only acts according to a basic standard of the rule of law, contrary to the court we have just heard about. Because the European Court of Justice is able to harmonize the legislatures of the member states partially. The rulings of the ECTHR are not binding, though. The judges need to apply the law when it comes to a dispute. And what is important is that the rulings are made only according to legal criteria and not, for example, economical or political criteria, or let's say religious criteria. What endangers the impartiality and independence of the laws are the other branches, namely the executive and the legislative, like the politics. In a constitutional state, the judiciary should be independent of the legislative and the executive. So the core of the independence of judges is the freedom from instructions. However, around this core, there are also different criteria. They can influence indirectly the judicial independence. So if judicial independence should work and be enforced, we should also have a look at these points. If we have a look at the ECTHR and the Article 6, Paragraph 1, since the 1980s, there are four main criteria which are always considered. First, the process of appointing new judges. Second, their terms of office. Third, existing mechanisms to prevent external influence. And a neutral or independent appearance. However, these criteria don't answer all the problems. So in the course of time, other criteria were added. For example, irremovability of the judges, freedom from instructions, secrecy of deliberations, immunity, that decisions are binding, salaries, and to my surprise, they say nothing about the re-election of judges. And only for a short period of time this century, we also look at the independence within the courts. which is the independence of judges from the panels, the boards within the courts, and so on, and what plays a role for promotion, for example. How these four basic criteria and the other criteria work together, I'm not sure what their relation is. The criteria I just named could just be could just complement the other criteria. Sometimes they are rather about the internal independence of judges, and other criteria about the external independence. What we can see here is that there seems to be no systematic approach. And I think it is difficult to develop a systematic approach since a judge's work differs from case to case.
Die breiteste Einbruchstelle für indirekte Einflussnahmen ist natürlich das Verfahren der Richterernennung. Und dazu ist
so the largest gateway how the judiciary can be influenced is in the appointment of judges. So when judges are appointed who are an extended arm of the political branch of the legislative or the executive, then we don't have independent judges anymore. But here we come across a difficulty which is larger than the European Union, who has 27 member states. I think the Council of Europe has 47 member states. So we have a great variety of different legislations. So if we just end, what is more, if we just look at member states' legislations, they don't necessarily reflect the state of judicial independence in the respective countries. So we don't really know how it works in practice. We also need the legal cultural background to assess the judicial independence in a country. We do have this option. And we know systems where where the regulations are such that politics could influence the judiciary, but they don't use that possibility. And there are other systems with checks and balances, but still the politics can influence the judiciary. For example, if a certain political party rules a country and is also able to influence the judiciary. Now, the ECTHR says that no system of a Council of Europe member state is actually incompatible with Article 6 of the ECHR. It then refers to the freedom of instructions. And then it says that it doesn't matter how the judges are appointed if they then are free from instructions. But actually, in the appointment of judges, we can influence the process, and afterwards, such instructions aren't necessary anymore because the judges listen to the executive, for example, anyway. And the ECTHR only judges according to the legislature whether the freedom of instruction is upheld. And according to this logic, the snake eventually bites its tail. The Committee of Ministers apparently favors a system of intermediary councils of judges, and many of the former socialist states went over to this system to assign the appointment and promotion of judges to such a body. But that doesn't really solve the question since we still don't know who is entitled to appoint the members of the body. So the ECTHR doesn't have a clear line here either. There is a different picture when it comes to the tie and terms of office. The terms of office are limited by law. So, but there are also legislatures where there are only very short terms of office of judges. The terms of office also play a role when it comes to the question when a judge has to terminate, to leave office. And here we touch upon the question of how judges are exchanged, who follows a retiring judge. So here we don't rely on the legal guarantees, but the legal guarantees are not touched upon if there is no practical implementation. So if we need to exchange judges within a court proceeding, this may work, but it needs to be a legal, but there needs to be a legal basis which doesn't exist so far. So the fourth reason is the appearance, whether a court, it doesn't only have to be independent, but the public or the citizens don't have to believe that they are truly independent. And here to make sure whether this criterion is fulfilled, the ECTHR refers to the three above mentioned criteria. And here again, the snake bites its tail. I actually don't have the time to touch upon examples, but I can only give my assessment here. I think that judicial independence depends on many individual factors. Dangers are present on different levels and come from different directions. And if we want to assess the independence of the judiciary in a country, we need to assess all these individual factors. So if we want to ensure that a judiciary is independent, we need to have a look at the practice and not only at the laws. So what we do at the moment is always only looking at individual factors or criteria or rules and regulation, and then we want to exchange or modulate individual factors. But one factor doesn't decide whether a judiciary in a country is independent or not. So if we talk about the appearance of independence, that doesn't say us much. So if we, as I said, want to assess the state of a country's judiciary, we can't only look at the laws. We need to consider the practical implementations. And there are individual judges who say that we must do more in that field. So the task of the ECTHR to ensure an independent judiciary in its member states can be fulfilled based on the options the court has at hand at the moment. So I'm very honored that a person who is a specialist in this field is present here. She is the next speaker, and all the mistakes I made, you can now remedy. Miss Angelika Nussberger.